Hello, everybody, and welcome to our podcast. For those of you who don't know me, my name is Niamh Minihane, and I'm a partner in the inheritance protection team at Gardner Leader Solicitors. And I'm here with my colleague l.butcher, who is a senior associate in the inheritance protection team at Gardner Leader. So, hello, Lucy. How are you?
Hi, Niamh. I'm very good, thanks. How are you?
Good, I'm good, thank you. So today, Lucy, we said we were going to talk about, continue from our previous podcast about lasting powers of attorney. It's a hot topic, a hot subject. And we were going to focus on one of our frequently asked questions, and that was about attorneys. Lots of clients of mine ask me, who can I appoint? Who can't I appoint? How can they act? What decisions can they make or can't make? So we just thought we'd just give everybody a bite size about attorneys themselves.
Yeah, absolutely. So that is definitely one of the most asked questions in people paying LPAs. And I think one of the things I always say to them is ultimately they must trust their attorneys. Because ultimately they can sign any document that person would normally sign themselves, and they can make any decision that person would normally make themselves. So going back to basics, just to remind people, you can appoint one or up to 4 people to act as your attorney. They can be members of the family, they can be children, they can be friends, or they can be professionals, and they can be a mixture of all of those. But I think the fundamental thing that people need to remember is they must trust their attorneys.
Yeah, that's key. That really is key, because an attorney has got a huge amount of responsibility. And so it's ultimate that you trust those people, because the attorneys themselves have a duty to act in your best interest. So any decision that they make on your behalf has to be within your best interest. So another thing, Lucy, is the questions that are asked about the attorneys is how they can act. If they can act, can one make one decision, another make another decision? What do you normally advise?
So I'll be honest, this probably comes down to the type of power of attorney that we're talking about. So if we focus just initially on the property and financial affairs one, I would normally, and I probably shouldn't say this, but I'd normally sway my clients to appoint attorneys on a joint and several basis. The reason being is that it's quite an onerous task for an attorney. And let's say there are 4 attorneys, let's say 4 children, and they're all dotted around the country. If they were appointed to act jointly, it means all 4 of them would have to sign the same documents and make the same decision at the same time. If they were appointed on a joint and several basis, it would mean that either one of them could do something for them or make a decision. And I think if you trust your attorneys, that's why you're appointing them, is because you trust them. They will always act in your best interests. And they should liaise with each other. But ultimately, you'll normally find that one of the attorneys will take on the lead role of doing the day-to-day things, and then involve the others if there's any key decisions to be made.
Yeah, exactly. I think as well, if you appoint them jointly, if one of them dies, then the whole power of attorney fails and dies with them. So that's another reason why my clients tend to opt for the jointly and severally appointment. And another thing as well, Lucy, clients ask me as well with regards to, like I mentioned before, what can they do? What can't they do? And I think it's important for clients to know that within the power of attorney itself, you yourself can put restrictions or preferences or conditions that you would like those attorneys to adhere to. So that's something that as lawyers we can advise the client on, because we've got to keep it practical. They've got to be able to use it. We've got to be able to give the attorneys flexibility. But of course, everybody's got their own opinions and concerns, etc. And I think that's why it's good to come to a solicitor like you or myself to be able to guide them really and advise them appropriately.
Yeah, and the health and welfare power of attorney, and I don't know about you, but it's slightly different, because that is the more health and welfare side. So that is people making decisions about your health, what medical treatment you can have, if you need to go into a nursing home, if you need carers, and I think that is a very different type of decision making to the property and financial affairs. And it might be that they choose to appoint their attorneys on a joint basis for the health and welfare, so that actually their attorneys are coming together and making those decisions together.
Yeah. And there's the important part in the health and welfare about life-sustaining treatment, which is really important to clients. But also it's important to note, this is more side with regards to the actual preparation of the power of attorney. They're very similar with the appointment of attorneys, but you're right. The ones that you have you might have one attorney who's very savvy with finance, and they would be ideal for the property and financial affairs. You may have a member of the family who is able to make the right decision for you in respect of your care. So they could be an attorney for the health and welfare. But again, coming back to the lawyers, that's the kind of thing that we'll take clients through. I find that it's a bit of a journey for some clients, isn't it? Sort of making that decision, but it has to be the right one. And I think what's important is we are here to guide our clients with that decision. So
and the other question I think that I get asked commonly is when my attorneys can act. So there is a part in the power of attorney, isn't there, where we can specify whether there's any restrictions as such in place. So one of the most common ones could be that my attorneys will only act if I lost mental capacity. And whilst that might be fine if someone's nervous about doing a power of attorney, my advice will always be, again, why would you want that restriction as such in place? If you trust your attorneys, I would leave it open. And actually, what we need to consider, and I think what clients don't really think about, is if they're physically unable to do something, but mentally their capacity is absolutely fine, and there is that restriction in place, they won't be able to ask their attorneys to use the power of attorney because they have got capacity.
Yeah, Lucy, just you mentioning that now has just reminded me of a client that I have who had a power of attorney for property and financial affairs. He was a young bloke, and the thought was, well, do I really need one? As a matter of fact, he made it. He then went on a skiing holiday and had an accident where he's paralyzed now from the neck down. So although he's mentally capable of making his decisions, physically he's not capable of perhaps going to the bank or doing the other tasks that his attorney now can do upon his instruction. So that's a good example as to why we would keep the power appointed whilst you have your capacity. But anyway, Lucy, I'm really, really, I could, like I say, I love this subject and I could talk about it forever. I was thinking actually perhaps next podcast, if we stick to the powers of attorney, but more on a twist of the business element. If you're a business owner, how will it impact you if you have a power of attorney in place? What do you reckon? Would you be happy to join me for that?
Yeah, absolutely. That sounds great, Niamh.
Okay.
And hopefully I would have had my hair cut by then.
I'm getting mine done tomorrow, so
very jealous.
Yeah. Okay, Lucy, take care, and I'll see you very soon.
Thanks, Niamh. Bye.